Welcome to This Plus Podcast, the Employment Law Counselor, hosted by Jeff Stewart. Before we get started, we'd like to remind everyone that the information and opinions expressed by our speakers today are their own and do not necessarily represent the views of their employers or Plus. The contents of these materials may not be relied upon as legal advice.
Hello, everyone, and welcome to the Employment Law Counselor Podcast. I'm your host, Jeff Stewart. Today, we'll be covering the one thing that can make or break you in an employment-related lawsuit: documentation. This podcast is a collaboration between White & Williams, LLP, and Professional Liability Underwriting Society, commonly referred to as PLUS. While our podcast is not legal advice, it is a practical discussion between two attorneys that deal with the maze and minefield of labor and employment laws on a daily basis. If you like what you hear, please give us a 5-star review and subscribe so you never miss an episode. Today, I'm joined by one of my colleagues at White & Williams, Laura Corvo, who practices out of our firm's Newark, New Jersey office. How are you doing today, Laura?
I'm doing great. How are you, Jeff?
I'm doing great. I'm ready for a lively discussion on documentation. How about you?
I'm ready as well.
All right.
Sounds great.
Then let's dive in. Laura, you and I have done a number of talks for clients, for trade groups, etc., and lawyers such as us regularly say document when talking about dealing with employees and employee issues. I guess I'll just tee you up. Why?
Yeah. I mean, it's the thing we always say, right? Document. Say it 1,000 times a day to clients. And I think the reason why is because with your employees, you're telling a story, right? You're telling a story to your employees about what you expect from them. You're telling a story if your employee separates from you as to why they separated from you, if your employee was disciplined as to why they were disciplined. And the documents will control that story, right? If we don't document, then the employee comes in and tells a different story. And suddenly you're faced with a case, and we get this all the time, Jeff, you know this, where the employer calls you up, tells you they had this employee who was horrible, who did X, who did Y, who did Z, who did this, who did that. And you say, please send me the documentation. I never saw the documentation. And then you get the complaint saying, hey, this employee was stellar. They did everything right. They were the best. And now all of a sudden you've got a dispute and you're stuck with it. If you have those documents, the story is in your control.
Absolutely. And, I always tell people, while good documents can help your case, bad documents can sink your case in a heartbeat. And in fact, the lack of documents, as you were saying, can absolutely just send you into the morass of he said, she said that nobody wants to be in.
Exactly.
So one of the things that I don't think people talk about enough is the fact that even before you have a lawsuit or before you have an EEOC charge, that's when you need to be creating the documents as if something is going to end up in litigation. Would you agree with that?
I would agree with that. And I would even take a step back from litigation, right? So the documents are important because we never want to get to litigation, right? We never want to get there. So if you never want to get there, you've got to send your employees clear messages. What do you expect? What did they do wrong? What did they do right? And the documents are a way of saying that. And it kind of pins the employee into a spot. You're not allowing that employee to try to wriggle out of anything. I expect you to show up on time to work every day. And yesterday you were late. So I'm going to let you know that in the future, I want you to be on time. It's a very simple message. You don't document that, then suddenly the employee says, well, hey, all these other times I came in late, and now all of a sudden after I've done X, Y, or Z, or after I filed a complaint, you're putting this in writing. So, if you have the documents, you're controlling the story, you're controlling the employee. It certainly helps in litigation, but I think it helps avoid litigation. The clients that I see get into litigation the least are the ones with the really good HR departments who are documenting everything, who are just buttoning up the whole process from day one.
Absolutely, because employees should never be blindsided when they're going to be terminated for cause, not necessarily, but it's not a layoff situation. But they did something. It shouldn't be a surprise to them, especially if it is a buildup of a number of things. They're not meeting expectations. You should be sharing expectations with them and documenting that. And, they should be a part of it. And they know that it's been documented so that, you are much less likely to have litigation on the back end.
Absolutely. And it should be all along, not just at the performance review stage. I had actually a friend who had worked in a law firm, and come the year review, got a terrible review, and he rightfully said to his supervisor, this is coming as a shock to me. Why did you wait so long? If I was working at McDonald's, would you wait until I burn the fries to tell me I was doing it wrong? Like, I wanted to know earlier that this was happening so I could correct my performance.
Absolutely. Let's segue into what are some properties of good documents?
Well, I think the first is contemporaneous. We kind of alluded to this earlier, which is, you want to do this all along, and you want to do it while the employee is performing either well or badly. So, you don't want to wait 6 months to say, oh, by the way, do you remember back in January when you did X, Y, and Z? Well, now I'm going to write it up. That doesn't look right. You want to write, if somebody performs poorly on January 1st, by January 15th, you want to get that right up to the employee. It's got to be pretty quick, close in time to when the employee made the performance error.
I could not agree more. Unfortunately, I've seen many times where, things are documented a month later, or, oh, the person has now been late 3 times. Okay, well, have you written them up? Well, I'm going to just include it all in the last write up. So we have one from December, one from March, and then one from May. And we're going to give this to them in May. Well, you can't be talking about somebody being late back in December in May for the first time. It needed to be addressed in December. It needed to be addressed when it happened, or again, as you said, within a couple of weeks. Absolutely.
Absolutely. And I think when, in addition to it being contemporaneous and done near the time it occurs, you also have to be specific in what you're telling the employee, and describe not just what the employee did, but what the consequence of that employee's error was. So, I recently had a case where a client said, one of my employees completely screwed up the inventory system. They weren't following the procedures. The whole inventory of the client systems was out of whack. And as a result, all this inventory got lost. There was, financial consequences to it. They had to go back and reconfigure the whole inventory. And they're like, we wrote the employee up. I'm like, great. And I said, send me the write-up. And the write-up was not performing up to expectations, didn't follow inventory procedures. And I'm like, but that write-up doesn't tell me the story you just told me. The consequences aren't there. So yes, the employee wasn't following the procedures. Yes, she wasn't meeting their expectations. But what does that mean? Explain why what she did was wrong and what the consequences were, both to tell her and then to tell a potential jury, court, EEOC, whoever down the road, that that's what the consequence was.
Absolutely. I couldn't agree more. And in addition to that, we want specifics. Again, I'm going to use the lateness. If you showed up at 8:01, it's a little bit different than if you showed up at 8:38. When 38 minutes late versus 1 minute late, those are very different things. The other thing that I like to see in a good piece of documentation is not only what's the consequences here, but what's the consequences if this happens again? If this happens again, will it be immediate termination? Well, in the inventory example you just used, I imagine it would be. But if someone shows up late again, is that going to be, will it be now escalating to a written warning or escalating to a suspension, something to that effect? Potentially, depending on what their history is. So I'd like to see that in a good piece of documentation.
Absolutely. I think that is crucial to, again, having that information, because lateness, for example, is one where, You're 5 minutes late. What does that mean? But when it builds up and when there's 5 latenesses, 10 latenesses, and then the latenesses cause other people to have to pick up your slack, that's the story you need to build. And a lot of times employers miss that. And I think it's an important lesson.
Absolutely. And then another piece of effective documentation, I think you need to be able to show that, if there is a policy, you should be referencing that policy. Our handbook says that you need to do X, or your schedule is specifically 8 a.m. to 5 p.m. and you're showing up late. And you didn't follow the proper call off procedure. If we can reference a company policy, we should absolutely do it. So it's not just supervisor policy, or it's not seen as subjective. It's much more of an objective issue.
Absolutely. I think that's extremely important, because oftentimes, at a deposition, you'll get, well, where was the policy that they were supposed to do this? And if it's right in that write-up, there's just, it's so buttoned up that there's no question. And suddenly you're able to more easily defend a claim. The other thing I think with documentation that's really important is consistency amongst your employees. What you never want to do is, write up one employee for being 5 minutes late, but not do it to another employee. If your policy is you got to show up at 8 o'clock and you're going to ding people for not showing up at 8 o'clock, then everybody who comes in at 8:05 should get the write up, even though maybe they're performing well otherwise. It doesn't mean everyone's going to be fired as a result of it, but they should at least get the notice to say, hey, that this is what our expectation is. Again, these documents are a communication to both your employees and the world that this is what our expectation is, and this is what we're holding. This is the fire that we're holding your feet to.
Yeah, and that actually is a nice transition into some properties of bad documentation. And as we were preparing for this, I kind of wrote down a few a few traits of bad documentation. We've kind of hit on a couple of them already. You just referenced being inconsistent, as one supervisor writing up for 5 minutes late, another one not. Another piece that I will throw out there is documentation that is never shared with the employee. Oh yeah, you were late. We noted it. We never talked to you. We never did anything. But it's noted in our supervisor notes.
Yeah, it goes back to my friend saying, well, if I'm burning the fries, why didn't you tell me about it? You want to, and I guess there's a lot of people say, should you have employees sign off that they received the documentation? I don't necessarily know that you have to have them say they agreed to it, because that's going to invite a dispute. But I do think that the supervisor or who's ever issuing the counseling should document that they met with the employee, explained it, the date that they did it, and, that it was delivered to the employee, so that at least you're, again, on notice. You put the employee on notice, but you're remaining in control of that story.
Absolutely. And then one of the other pieces of bad documentation that I have seen is when the document is internally inconsistent, or internally is not supporting the stated reason. And I'll give you an example. I had one matter a few years ago where the company was disciplining an employee for leaving work early without permission. The person left at, let's say, 3 o'clock. They were supposed to be there until 5. The documentation that they put together said that the person showed up late that day and did not work a full shift. Well, showing up late is very different than leaving early. So the documentation that they had for that date in question didn't match what they ultimately were disciplining her for. And that's problematic.
Yeah, I often think, and I don't know what it is, but employers are able to orally tell a story and then they get the computer or the piece of paper in front of them and suddenly they freeze and don't tell that story. Just put the same story that you're telling me into the paperwork. Like there's no magic trick to how to document other than to, you know, be specific and state the facts. I like to use the old Columbo, just the facts, ma'am. You're going to state the facts. Tell me what happened. On this date, at this time, this person was 10 minutes late. Or this person left early. As a result of that person leaving early, that we were short-staffed and, people had to scramble or we weren't able to service the customers the way we normally were able to. Whatever it was, just write it down and write it down just like that. It doesn't have to be, War and Peace or a great novel. It just has to be facts. The exact facts that you would tell conversationally, you want to put into the documentation.
Absolutely. So let's shift gears here a little bit. We've kind of referenced a few places that documents will be utilized. Obviously, if there's an EEOC claim, if there's a lawsuit, those get, you'll be utilizing your documentation there. Some other common places, unemployment. I mean, the first thing that unemployment referees will look to, or even, just the unemployment system before you even get to a hearing, that they will ask for is, all right, if this person was let go, why? And what documentation do you have? And that's, I'll say, one of the most common areas that you see documentation being necessary.
Yeah, absolutely. And again, you want that documentation to tell that referee the story. Why was the person let go? And if it's just, and oftentimes employers don't tell the true reason why somebody was let go. They kind of twist the words or they go out of their way to say something. Just say what, if the person was let go because they've been late 5 times and they show up, they leave early and they aren't meeting your expectations, then just say that. It doesn't have to be, some magic twist to those words. Just say it. And I think, unemployment referees, EEOC investigators, or juries, if we get that far, will understand it.
Absolutely. And I've used, and I know you have as well, documentation to stop a claim before it starts. And I'll give an example. I had a client several years ago. They received a demand letter from a plaintiff's attorney prior to any kind of lawsuit or anything, saying that they had terminated this employee while they were on a medical leave, and that's a violation of the FMLA, of the ADA, and if they didn't do A, B, and C, they were going to be sued. Well, client called me up and said, this is just all wrong. We did everything we're supposed to do. I said, great, send me the documentation, which they had. And we were able to show that the person applied for FMLA leave, but they had already exhausted their 12 weeks. We had informed the employee that we were still going to allow her to utilize her sick time, which she had, I'm going to say, 4 weeks or so. And, she still needed more time off. We could have discussions at that point. So they allowed her to use all of her sick time. They then reached out to her and she never responded. And then we had multiple letters, including a certified letter signed for by her that said, we have not heard, we have allowed you to take this leave. We've extended, to allow some unpaid leave. However, we have not heard from you in several weeks. We need to hear from you within 7 days. Otherwise, we're going to assume that you've abandoned your job. And they never heard from her until they got this letter about a month later from the attorney. So I shared with the attorney the documentation we had, including her signing for the letter saying, you need to contact us. And when she did not, we let her go. And they never filed a lawsuit or an EEOC charge or anything. It just went away because the employer had strong documentation from beginning to end to show that everything they did was proper.
Absolutely. I think that more often than not, the best reason to document is to avoid the litigation and the EUC coming knocking on your door. And, like you said, you can often, ward off a plaintiff's attorney who may think when they speak to their client that they have this great case, but when they see the documentation, suddenly they're shied away from it because they realize, hey, I'm not going to put time and effort into this because this is not what I thought it was. And I think even before that process, the documentation is important to just communicate to the employee. Like, I think most employers don't want employees to fail. They want the employment relationship to succeed. So if you document, if you communicate to the employee what you expect from them, then, hopefully the document has the effect of having that employee changing their behavior. Hey, they're really serious about me coming in on time, so I better show up on time because I've gotten this write-up. So now I'm going to come in on time. That document, helps the employee change their behavior and hopefully avoid not just a lawsuit, but having a successful employee.
Absolutely. So we've talked about a lot of areas where documentation is utilized, but there's a couple areas that we haven't talked about that I think it's important for our listeners. One of them is in hiring decisions because, as you know, in failure to hire cases, interview notes can be key pieces of evidence. Can you talk about those for a moment?
Yeah. So, oftentimes you're going to have to come up with a decision as to why one employee was hired over another. What were the reasons? What were the factors you were looking for? And, you have to be careful in hiring notes. You want to make sure that what you're taking notes on is information about the employee's ability to perform the job and not protected characteristics. This person was old, this person was of a particular race, religion. You don't want to take pictures, but you do want to have some documentation and to show what it is you were looking for in the job and why one person met it over the other. And I think that goes back to not just your interview notes, but documenting what the job description is. What are you expecting? And even putting that out at the onset of the interview process. What are you expecting of the candidates? If you say you have a job and you call in candidates and you say, well, I chose this person because they have a college education and the others don't, the job description doesn't reflect that a college education is required, then, you could have a fact issue. So just being consistent and having the documentation just from the onset of what are you expecting from this job? The job description is, I think, the first place you start.
Absolutely. And beyond that, some other areas where, we need to make sure we document things. Documenting the fact that your employees receive their employee handbook and or policy changes. We need to be able to show that employees were aware of our policies, that they're expected to follow them, and that if we've changed them, we've made employees aware of them. Because anytime we get into unemployment situation, litigation situation, if there's a question of the employee violated a policy, the first question that's going to be asked every time, are you sure the employee was aware of the policy? And we need to be able to show that, yes, they were.
And not only that they signed it at the onboarding. So you have an employee who's been with you for 10 years and signed the employee handbook 10 years ago. That's not going to be helpful to you. That handbook needs to be updated. Those policies need to be updated. And when I do handbooks, I have employers not only sign off on the fact that they received the handbook itself, but the specific policies within the handbook, which I think will most likely be challenged. Things like the harassment and discrimination policy, the confidential nature of work policy, your computer usage policy, where they're specifically signing off on it and not signing off on it once every, just at the beginning of the employment, but every year or 2 years so that they're refreshed on it. And again, when you're sending out the handbook, again, I don't like to just send out, oh, we got a new handbook. Here it is. Have a meeting with people. have a Zoom call saying we've got a new handbook. Here's what's changed. We have a new vacation policy. Here are some of the highlights, and keep documentations of what that communication was about. And then, of course, have the employees sign off on it. It's a communication role that we're really trying to play here, to just, again, explain to employees what we're expecting of them.
Absolutely. So as we start to wind down here, a couple of questions that I get asked by employers with regard to documentation. Should an employee be required to sign? And I think you said earlier, no. But if you're an employer who does want employees to sign, what should you do if an employee refuses to sign?
And that's one of the reasons why I don't like having the employees sign. I almost like to control it from the start, where I say, we gave this to them, we had a meeting on X date, it was presented to them, and, but yeah, if the employee refuses to sign, I think you have to document that they refused to sign, that you presented the information to them so that everyone is aware that that employee heard the information. The employee may not accept the information, but you want to make sure you show that you delivered that information to that employee. That's really what's important here, is the delivery of the information. You can never force an employee to accept what you're saying or admit that this is, they've done it wrong. But you can say, we had a meeting, we presented you with this, and we told you. And then it's in the employee's hand as to whether or not they want to accept it or not.
Absolutely. I just tell employers, don't get into an argument. Just write, employee refused to sign, the time and date, and initial it.
Yep.
Move on
and just keep records that you showed it to them. That's all. Absolutely.
All right. So, Laura, as you know, I like to give our listeners a couple of key takeaways at the end of each episode. Do you have a key takeaway for our listeners?
Just that your document is your story. Your documents are your story, and you want to be in control of that story, and just tell it. Tell the story in the documents. The story you want your employees how you want your employees to behave from the onset, what your job descriptions are, what your employee handbook is, and then along the way, tell them how they're doing. And if you do that, I think your chances of having disputes with your employees really, really, really will be minimized. It's the document.
Absolutely. And I guess my key takeaway would be train, especially your first level supervisors, how to create documents and, frankly, how they're used. I did a training for an employer not too long ago where we trained their first level supervisors who had no idea how those documents get used. And we showed them, okay, in an unemployment hearing, this is how they're used. In an EOC charge, this is, these are the things that are looked for in litigation. And, they were kind of amazed to understand their role in the process. So that training is not just how to do it, but why it's so important. And when you get those first level supervisors to buy in, I believe you get much more effective documentation.
Absolutely.
Well, I want to thank you, Laura, and I want to thank all of our listeners for joining us here on the Employment Law Counselor Podcast, where we try to make sense of the world of labor and employment law. On behalf of myself and Laura Corvo, we thank you for listening. If you enjoyed this episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. For more information on this and many other topics, please visit the White & Williams website at www.whiteandwilliams.com, where you can visit our blog and learn more about the firm. Until next time, stay safe and stay compliant.
Thank you for listening to this episode of the Employment Law Counselor. If you haven't checked out the previous episodes, make sure to give those a listen and check back in the next few weeks for the newest episode. If you have an idea for a future Plus podcast, you can visit the Plus website and complete the content idea form.